Now, Washington Mornings on the Mall. At AM 630. WMAL.
7:07 on WMAL. Brian Wilson, Brian Neiman. It's Monday morning, and we are joined on the phone line by our good friend, our legal analyst, Joe DIGENOVA. Joe, how are you this morning?
I couldn't be better, Brian.
Well, over the weekend, it looks like they revoked the bond of one George Zimmerman in the Trayvon Martin murder case, and they are... I guess the question is, why did they do that? It had something to do with the fact that prosecutors felt that he was not absolutely truthful with the court when it came to revealing the assets he had available. Yes,
apparently he and his wife, through an online website, had raised money for his defense. And they apparently hid that information to the court during direct questioning from the trial judge in the case who was setting the bond and Mr. Zimmerman. And I'll tell you one thing you never do is you lie to a judge when you are being spoken to directly about something as simple as what are your assets. And the judge obviously got, once it was proven to him that they had the money and that they had the money at the time they made the representations in open court, he decided that Mr. Zimmerman was untrustworthy, and that therefore that meant that his promise not to flee could not be believed.
All right, so it goes a step further than that, because is this something that can be brought up in court later when the case is tried, when you start talking about the veracity of his testimony?
Yes, this is admissible evidence because it was given under oath in court to a tribunal, so it has inherent reliability, and they can prove it if, for example, if he decides to take the witness stand, they could use it to cross-examine him. They could also prove it independently. Even if he doesn't take the witness stand, they can prove that he said this and that the judge revoked his bail.
And does he go on the stand during this hearing at any point?
He may take the fifth at that point. He may very well be addressed by the court. His lawyer may make representations. If he does make statements, those too will be admissible and can be used against him. It's going to be a very interesting hearing.
So this is a big deal, not a little deal.
It's a very big deal.
All right, let's stay in Florida because the Attorney General of the Justice Department is demanding that Florida, the state, stop checking voter records in their effort to prevent illegal voter registrations. They say it is a violation of the 1993 National Voter Registration Act. Is the Justice Department right on this? Where do you see this case right now?
I think they are not only on shaky ground at the Justice Department, I think they're on no ground at all. This is actually a legal creation of the department. There is no basis to stop Florida from cleaning up its voter rolls. Even though Florida is one of those southern states that's covered by the Voting Rights Act and has to, any changes to their law have to be submitted to a federal court in Washington, there is no evidence that there is any animus toward racial groups or minorities. This is a legitimate practice which is going on all over the country to clean up voter rolls. It seems to me that this has a political tone to it that's very disturbing, and I think the department is going to get shot down legally in federal courts. I do not see them winning on this if they litigate this issue.
All right, we had a really interesting discussion earlier in the program about a case. Where was it out of?
It was Arizona.
Arizona. Finders keepers case. So this guy hides money in his walls and places around the house. The family, after he dies, finds most of it, but after 7 years, they sell the house. New owners do some construction work, and the contractor finds the money. A big fight is over who this money belonged to, and a judge and then an appeals court have ruled that it belongs to the estate of the man who died and therefore goes to the children. What do you think about this? Because I think it's just all kinds of interesting legal questions here.
Well, this is a law school course contained in one case.
Wow.
This involves the law of contracts, the law of property, and the law of what's called wills and estates. The bottom line is the court ruled that this property had been, quote, mislaid by the family and the guy who wrote the will, and not abandoned. I think that is completely upside down. This family knew about the possibility of property being in the house. They had 7 years to look for everything. They found some of it. They didn't find it all. They then decided to sell the house. You can only sell a house by a written contract under the law of all of our states. Unless there was a clause in that contract that said any property later found, like stocks, bonds, it would have to be spelled out. They are not entitled to this property. This is abandoned property. And it seems to me that when you transfer the house, you transfer everything in it. In fact, most real estate contracts say that. And the fact that unless there was a clause, after 7 years of having an opportunity to find stuff, unless the family put a clause in reserving these rights in the future, this money belongs to the new owners of the house, and I think the Arizona Supreme Court is going to reverse this decision by the mid-level Court of Appeals. This is a very bad decision. Now, it's an interesting case. It has, all the funny nuances and everything, but it's pretty fundamental stuff.
Right.
This is a contract, and unless you reserve those rights, that's not your property.
Does the time matter? I mean, for instance, let's just say they sold the house and like 2 days later they found the money. Would that make a difference?
It might, except in this case they had 7 years to look. And it seems to me, just from an equitable standpoint, forgetting the law, this is pretty bad stuff. I mean, contracts for sale of houses are final. In fact, the sale of a house in real estate is so sacrosanct that you can actually go to court and force somebody to sell you the house that they signed a contract for. It's called specific performance, and it's not favored in the law, but when it comes to real estate, that family, let's say the family that had the will, they sell the house and then they decide a month after they sign the contract they don't want to sell it to these new people. Those people who bought that house can force that sale. That's how important these contracts all are. So I think when it gets to the Arizona Supreme Court, the family with the will is going to lose.
We pretty much dismissed the fact that the contractor found the money and wanted to claim it for himself. He has no right to it, right?
He doesn't have any ownership rights in anything unless the family, in their contract with him, says he gets to keep whatever he finds. It belongs to the family doing the renovation.
All right. Lastly, John Edwards basically got off. I know you've been saying for quite some time that this was a pretty, I would say open and shut case. You didn't really think they had much of a leg to stand on the prosecution in this case. Have we ever figured out from the legal standpoint of why they wanted to go after Edwards, or was it just solely political for the reason for that?
Remember, this case was brought by the Public Integrity Section and the U.S. Attorney's Office in North Carolina. The Public Integrity Section gave us the Ted Stevens case, an ill-conceived prosecution coupled with prosecutorial misconduct. The North Carolina case involves a very bad U.S. Attorney's Office down there. They have a very bad reputation. They're known as cowboys. They obviously didn't like John Edwards. The legal theory behind the case was a disaster. It never should have been approved by the Justice Department, but the Public Integrity Section allowed them to go forward. Well, the judge made reversible error. You recall that during the trial, she took testimony out of the presence of the jury from experts on the Federal Election Commission who said this was not a campaign contribution. She did not allow that testimony to go to the jury. That would have been a reversal had John Edwards been convicted. But the jury was too smart even for the judge. This was a very conscientious jury, and if you heard them over the weekend, I was very impressed with them. They just said the government never met its burden, and they obeyed the judge's instructions to a T. But again, as we've been talking for the last number of months, from day one, this has always been a case that never should have been brought.
All right, Joe DIGENOVA, always good to have you.